Good morning, everyone. Welcome to the First District Court of Appeals. Today, we only have two cases up for argument, and I'm only going to read off those cases. We have several cases set for submission as well. The first case for argument today is DATFT LLC versus AM Reflection Cleaning Services LLC, and that's case number C220217. My understanding is that the attorney for the appellant, Ms. Hope Platzbecker, is here to argue. Okay, and my understanding is that the appellee, their lawyer withdrew, and they have not, new counsel has not made an appearance. So, Ms. Platzbecker, you'll get 15 minutes to argue today. Then we've got Will Fong versus Bush. That's case number C220308. Will the attorneys enter their appearances?
Yes, Your Honor. Good morning. My name is Nicholas Kulik on behalf of the appellant, Shahel Wilfong.
Okay, great, thank you.
My name is Donita Parrish on behalf of the guardian ad litem, Maureen Turner.
Okay, wonderful, thank you. All right, so Ms. Platzbecker, would you please come to the podium, and whenever you are ready, I will let you know when you have about a minute left with the yellow light, and then red light will mean for you to stop.
Okay, thank you.
Okay.
Good morning. May it please the court. This case is about the fair application of terms within a contract that the parties have already agreed to. Ultimately, the lease was ambiguous. There's two terms of the contract that we're ultimately focused on. The provision that provides for the tenant to be able to assign the lease with written permission from the landlord, and then the term in the lease that says the contract is binding on heirs and assigns. So this gave AM Reflections a lot of guidance on what they had to do in order to assign the contract, but it provided them with no information as to what DATFT could do in order to assign the contract.
Well, how does that make the contract ambiguous? It seems like it would be pretty clear then if there's no requirement for the landlord to do anything, then they don't have to provide notice or anything. I mean, how is that ambiguous?
So it left AM Reflections with the understanding that they would receive notice. Ultimately, a contract is ambiguous if, based on the reading of the contract and the words that are there, it is up to multiple interpretations and different parties could understand.
Which provision would you say is ambiguous? Which is the provision that's suspect to multiple interpretations?
The provision that says the tenant can assign the lease with permission of the landlord, and then just that it's binding on heirs and assigns. That silence, the lack of information as to how a tenant can assign the lease leaves it ambiguous. It left AM Reflections with an understanding that they would be given, at the very least, notice that the contract would be inside.
Do you have a case that you can point to that silence creates ambiguity to a contract?
So there is not a lot of case law that is particularly on point as to there being notice being required for a lease to be assigned, but there is the fact that AM Reflections was left without knowing who her landlord was. So then when issues arose, those issues compounded as she was contacting the prior landlord for 3 months as to the dispute over rent payments. And so that issue compounded and went on for 3 months before she was even given direction as to the appropriate party to address the dispute with.
So I assume that it's your position that a landlord-tenant contract does not default to the landlord being able to assign. That's
So we understand that contracts are freely assignable, absent a provision that states otherwise. We just don't feel that the landlord being required to inform the tenant that they had assigned the lease interferes with the fact that it's freely assignable. It's
Okay.
not a limitation. They don't have to get permission from the tenant to sign it. They have complete control as to providing notice, so it's still
Understood.
freely assignable.
What is the prejudice that was created by the lack of notification?
So AM Reflections and DATFT had a dispute over the way rent payments were being handled. And when the dispute first arose, she attempted to contact the original landlord about that dispute and got no response. And so the discrepancy in rent payments went on for 3 months. And by that point, there was a back pay in rent and just the general dispute over who owed who what amount continued to compound for 3 months. And so at that point, there was a dispute of a little over $1,000 compared to it would have been $450 had Ms. Taylor been able to contact DATFT directly at the first occurrence.
Well, counsel, isn't there evidence in the record that your client had some interpersonal difficulties with the new landlord? I recall reading allegations that the new landlord was sexist and misogynistic.
Yes. So Ms. Taylor, she's the owner of AM Reflections. Her and the landlord did have disputes, and that further added to the tension between the two. But it is ultimately our opinion that the tension could have been resolved or minimized had they not had that dispute over payment as well. So in addition to the negative feelings, they also each believed the other owed them money. So yes, there were negative feelings, but that was just added to by the dispute over funds as well.
And the dispute over funds had to do with the separate contract that you reference, which I don't think is in the record, but it's some sort of cleaning contract, right?
Yes.
And so your client withheld rent because your client believed that they were owed for the cleaning. Is that what happened?
Yes, AM Reflections had an agreement with the original landlord that their rent of the office space in the building was going to be offset by their cleaning services of the building. And again, that was compounded and made difficult by the fact that they were not informed that there was a new landlord because that agreement did not get communicated to the new landlord. So
Is it a written, I mean, I don't think that agreement is in the record, is it?
no, there's a lot of dispute over as to whether or not that agreement ultimately exists or not. It's not written.
Okay, so it was some sort of oral agreement.
Correct.
Okay.
And if it's an oral agreement, would it only be binding if it's going to be accepted as a contract as to the original parties that entered into it? It wouldn't carry over to the new landlord, would it?
Yes, but AM Reflections was not notified that there was a new landlord. So they were not aware that they needed to communicate with the new landlord whether or not that same agreement was still going to be accepted or whether or not they were still going to work under that same agreement. So AM Reflections continued to operate and clean the building as if that agreement was still in place because they were not notified otherwise.
How long did your client continue to operate and clean the building before they were notified that there was a new landlord?
3 months.
3 months, okay, thank you.
So is that, I mean, the notification is what you're saying, it excuses your client's breach of the lease agreement, the failure to notify?
Yes.
Okay.
It is our position that DATFT did not properly assign the lease by failing to notify. At the end of the day, we strongly believe that a tenant should have the right to know who they're in a contract with. They should have the ability to know who their landlord is. And without that notification, AM Reflections was not able to address issues that arose under the contract in a timely fashion.
Counsel, didn't your client know this new landlord? Can you help me understand how your client didn't know the new landlord when there are these allegations that there were the interpersonal difficulties?
Yes, so she did become aware of the landlord, but prior to that, when the building was first sold to DATFT, they were not notified of the sale. So then, once she became there started to be discrepancies as to the rent payments, and the dispute as to the rent payments started. And then, after AM Reflections had attempted to communicate with Sharon Square, the original landlord under the lease, she was informed that the building had been sold to DATFT. And in trying to work out those lease payments and the discrepancies in the lease payments with DATFT, that is when those interpersonal difficulties arose. Are there any other questions? I don't think I had anything else.
I do have one additional question. Returning to the point about contracts being freely assignable, case law indicates that contracts are freely assignable unless there's clear language in a contract prohibiting the assignment. You're arguing that there's an ambiguity in the contract. So can you point to any language in the contract that clearly prohibits an assignment by the landlord?
No, and we don't believe that requiring the landlord to notify the tenant is a restraint on assignability, where they have complete control over whether or not they are going to provide notice. It doesn't impair their ability to sign or assign or their right to assign, because providing notice is entirely within their control.
So what I'm hearing is that you want us to read into the contract a requirement of notification upon assignment?
Yes.
All right, thank you. That clarifies it for me.
All right, thank you. Thank you for your argument today. We will take the case under submission and issue a timely decision.
Okay, thank you very much.
Have a good rest of your morning. Okay, next case is Wilfong v. Bush. The parties would come forward. Mr. Kulik, would you like to reserve any time for rebuttal?
Yes, I would like to reserve 3 minutes.
3 minutes, okay. So I'll turn the yellow light on when you've got about 1 minute left of your first part of your argument.
Good morning, Your Honors. May it please the Court. We are here today because Ms. Wilfong, the biological mother, requests this Court to find that the trial court abused its discretion when it failed to properly weigh the factors contained within ORC 3109.051D1. The Court abused its discretion because its decision was not a result of a sound reasoning process, because the facts contained in the record did not support the finding and decision made by the trial court. The first error that the trial court made when it determined that the health and safety of the children were in danger under a mother's care that would prevent a complete ban of her parenting time. However, the facts in the case indicate that the mother had significant parenting time of up to 4 days a week before her parenting time was suspended. There was also an incident at mother's house in February of 2021 where one of the children did sustain severe injuries. However, Children's Services did investigate the matter, and to this day the case is still open, and no substantiated evidence has come forth to suggest that the mother was the result of those severe injuries. There was no police investigation, and there was no criminal charges as a result of that case.
So are you arguing that the trial court should not have considered that at all?
She could have considered it, but the two errors that was made by the trial court, one is that there was no evidence presented to the court that definitively say that mother was the result of the injuries, and two, even if the trial court properly did find that she was the perpetrator of those harms, it wouldn't warrant a complete ban of her parenting time. The mother, with the exception of 2 days ago for one of the children's birthday, has not seen the children at all. for over 2 years.
When looking at your arguments, I felt that a large portion of your brief seemed to suggest what you just said, was that this was too restrictive or too severe of a restriction on seeing the kids. Is there some case law that suggests that the court has to look at the least restrictive means to protect the safety of the children, or?
The mother does have a constitutional right to be involved in the upbringing of her children. That doesn't necessarily mean that she has to have custody of the children, but that she should have some type of interaction with the children.
Is there case law in that regard, that that the court has to kind of look at, is supervised visitation potentially an option instead of banning her from seeing her children at all?
I don't have a case before you today to suggest that. However, I do know it's certainly the state of Ohio's practice to look at alternative means for parenting time to adhere to that constitutional right to be a part of the upbringing, such as supervised parenting time, either at a facility, public places, restaurants. There are services that you can hire people to come visit, supervise at your home, or a typical practice is have a family member come supervise at your home to make sure that the children's safety is ensured, but also having parenting time for mother and the children.
Did mom present any evidence of these alternatives at the hearing in the juvenile court?
She did suggest that we could have supervised parenting time.
What was her parenting time prior to that? Was it unsupervised?
It was unsupervised, and the parties, mother, it was a weird parenting time schedule where father had custody of the children, yet mother actually had more parenting time than father. Mother had 4 days a week, and father had 3 days a week. So there was substantial parenting time. The mother resided in her home for 7 years during that time period, and the GAL testified that she had no problems with the home. The minor child that could be interviewed, it suggested that she desired parenting time with mother and didn't have any concerns when she was with mother.
Were there other considerations that the juvenile court took into consideration in determining to terminate mother's visitation in this case? It wasn't just this one incident, was it?
Yes, Your Honor, there was other things considered. Another error that mother proffers to the court is that they considered her mental health as a concern. The GAL testified without any evidence that she had concerns for mother's mental health. Job and Family Services didn't even conduct a risk assessment to determine whether or not mother had any mental health issues. She doesn't have any mental health diagnosis.
So, you said without any evidence. Did the GAL explain what that was based on then?
She doesn't in her testimony. If you look at the record and the transcript, she just says that she has concerns, but that's it.
Doesn't explain any reason why.
No, she doesn't.
Okay.
Can you address the noise issues in mom's home? Wasn't there some report as to one of the children needing a quiet environment and mom's home being too loud?
Yes, there was a concern about the potential noise issue in the mother's home. One of the children have cerebral palsy, and it was offered to the court that noise issue might be a concern. Again, there was no expert testimony or any medical opinion about whether the noise level, if it rose to that level, would be a concern.
I didn't understand what that was. What noise?
There was an allegation that the noise was to a level that was bothering the child, and there was no witness testimony.
What kind of noise? Like, are we?
I don't know. It was offered I believe it was the GAL or father about noise levels at the home. So the children lived there. Mother testified that she never had observable problems with the child.
So you're telling me that this entire case they talk about noise levels in this house, and there's no indication of what we mean by that?
Correct.
Like TV or a train nearby or people yelling? I'm just having the
Without having the whole record memorized, they might have said something external that was causing it. There was no specifics within the home, so maybe there was noise level outside of it. But again, even if that noise level was there was no professional opinion whatsoever that that would affect a child with cerebral palsy. It was just offered that we think this is an issue without any professional expertise to know if that was even an issue or not.
Okay. They also said chaos, noise and chaos. So no indication on what we mean by chaos?
And there was no witness testimony that chaos was even going on and what that was. So it might have been an offer that things are disorganized and perhaps, causing an issue, but it was just offered, as they didn't even explain why it was an issue or what was affecting the child specifically.
Okay.
So is it in essence part of your argument that some of the determinations are not supported by the record?
Yes, correct. The issues are said, like, for instance, mental health concerns, but then no one delves into why or what they actually are, because those are buzzwords for, during a court that a mother has mental health concerns or the house is disorganized, and that would be a reason they're not even reasons to suspend parenting time completely, but those are things that they're going to consider, but you have to delve deeper into what they actually are and how it's affecting the children.
Yeah, it sounds like your other argument is, so the trial court is supposed to take into account all relevant factors in the order that they're going to be making, and it sounds like you're arguing that the factors that were considered were not in fact relevant for the suspension of parenting time. Is that what I'm understanding?
Yes, Your Honor, completely. If the decision was to limit mother's parenting time from 4 days to 2, or have supervised visits at our home, it would be more in line with our reasoning, sound reasoning process, because those are typically what a decision could be made. But to say that you're never going to see your kids again, it has to be something so severe that would prevent that. We cited, in oral arguments in front of the judge and the objection to the magistrate's decision, that even dependency cases where parents are sexually abusing their children or commit atrocities to the children, they still get supervised parenting time at a facility. And so in our case, where the mother it didn't even have a substantiated claim of neglect or abuse from Children's Services, she can't see her kids at all. And that's just not in line with the court's practice.
But you would agree it would have made sense, as you're arguing, for the court to have, based on these concerns, this is being investigated. You have one child that was severely injured, no explanation for what happened. Apparently, mother's explanations constantly changed. I thought I saw another child, the other child had some bruising. Is that the case? There was some bruising noticed on the other child?
There might have been.
Okay, so the court has this information in front of it. Maybe supervised release seems to be what you're arguing, or supervised release, supervised supervision or visitation would have been more appropriate.
Correct. And in the beginning, in February, when the court had an emergency hearing and suspended parenting time, that could be seen as reasonable, because that's a typical court process. A Job and Family Services, Children's Services investigation is open because events that we don't know what happened, but It was concerning. So let's suspend parenting time during the investigation to find out what actually happened. Let's protect the children. This case is unique in two instances. One, the Children's Services case is still open after 2.5 years. You either have to close it or find some disposition. If you don't have any evidence, you have to close it. It's
Any
still
indication
pending.
why it's still open after 2.5 years?
They haven't indicated why it's still open.
Is that in the record, counsel?
That the case is still open?
The status of the investigation?
Yes, it was still open. On cross-examination, I questioned as the attorney, asking, is the case still open? And actually, what would be the guardian ad litem's position if the case was closed post the trial?
Counsel, I hear you arguing as a reference point what normally occurs or what is typical in these kinds of cases. Are you suggesting that we weigh whether the trial court abused its discretion in this case against what might be normal or typical? Do you understand my question?
Yes, Your Honor. I do believe that the court has to take case precedent into effect, and this is a circumstance that has occurred before, and we should have a similar result to that. And it is one argument, and the other argument is that the facts presented at trial do not support a complete ban of the parenting time.
How would we know what is normal or typical? What body of law or evidence should we look to assess what is normal or typical in these kinds of cases?
You could look at previous case law, or even if case law wasn't cited, you could look to the facts and evidence and what's a reasonable outcome for parenting time, or a modification in the parenting time order that was previous based on what facts were presented at trial.
And returning to my question about what mom presented at the hearing below on supervision, were there other family members who would have been available to supervise visits? Was anything like that presented? Maybe a grandma, an aunt, cousin, something like that?
I don't believe a specific person was indicated for parenting time. That's something that's typical. Mother and father have had issues in the past working together for parenting time, so that might have not been the best alternative. However, if it is, then that's something we try to look for the most, because if a grandma can come in, then the child gets parenting time with another family member as well, and we're going to ensure that the children is safe at the same time.
Thank you.
Mr. Kulik, you are at your time if you'd like to reserve your time for.
Yes, Your Honor. Thank you.
Thank you. Ms. Parrish?
Thank you, Your Honors. My name is Donita Parrish, and may it please the Court, I am the attorney for the guardian ad litem. This is a case involving very vulnerable children. We have a nonverbal child with cerebral palsy and autism who suffered extremely serious injuries in mother's care that required emergency transportation to the hospital and being put on a ventilator for a time. At that same time, in February of 2021, the sibling had unexplained bruising. Mother's story about how these injuries to the child happened changed, and she couldn't explain what happened. We have a child who, even though there's not been clear evidence that mother caused these injuries, who needs a high level of supervision. So at a minimum, mother failed in her duty to care by not supervising the child, by having these unexplained injuries that she even alleged that perhaps the paramedics had caused.
But she hasn't been criminally charged. The investigation hasn't been substantiated. Why is discontinuing all contact with her children the appropriate action in this case?
I think from what mother's attorney said, mother has seen the children recently. The court did not give mother parenting time, but in terms of ensuring the safety of the children and in terms of the other issues that the court had from the past of mother not evidence in the record that mother had completed a diagnostic assessment of functioning through Children's Services in 2018, had not completed the recommended services, that mother had serious incidents of domestic violence against father, choking and attempting to tase him, and had not completed Women Helping Women that she was referred to in 2016. So taking the totality of the evidence that was before the court, it was very reasonable for the court to make this finding that the safest thing for the children was not to have court-ordered visitation.
How is it that the
For
mother
mother.
has had contact with the children when parenting time is suspended?
I'm sorry?
You said that the mother did in fact have contact with the children. recently.
Mother's attorney just stated in his presentation that mother recently had contact with the children.
I thought he stated that she has not had contact with the children for a considerable amount of time.
Are you aware that mother has any sort of visitation rights with these children?
Mother does not have court-ordered visitation rights with these
So
children.
the court
no.
order, what's in place right now is the mother is to not have contact with her children.
Correct.
And you're saying that based on this past issues with not completing certain assessments and violence against the father of the children, that taken in with the investigation going on is enough to stop her from seeing her children at all.
Yeah, and Your Honor, yes, Your Honor. That taken with all of the things that the court weighed in addressing the best interest factors for custody and visitation, the court had ample evidence, the history of violence towards father in the presence of the children. It's significant that that was in the presence of the children. The serious injuries that that RW suffered and the injuries that BB suffered, a mother's history of not following court orders in the past and keeping the child from father, evidence that when the child was in mother's care during that time in 2020, that the school teacher reported a deterioration in RW's behavior, including self-harm and aggression.
But why not supervised visitation?
In order for the court to make a order in a private custody case for supervised visitation, the person requesting that needs to offer what that would be and offer someone to supervise.
Okay.
In the absence of,
That leads me to the question I have. Did mother request supervised visitation as an alternative before the trial court?
no, mother may have mentioned supervised visitation, but mother did not provide information to the court that would have allowed the court to assess a specific recommendation for supervised visitation and the information that would allow the court to make such an order. So in order for the court to order supervised visitation, there needs to be a willing supervisor whose appropriateness the court can assess in order for that to happen. There are agencies that provide supervision.
So even if it was the family nurturing center, the parent requesting to supervision would, in essence, have to have some form of arrangements or some sort of acquiescence to allow for that to happen.
So typically, agencies like the Family Nurturing Center are used in abuse, neglect, dependency cases when Children's Services is involved and is paying for those services. There aren't really a lot of options for supervised visitation for private custody litigants, particularly affordable supervised visitation. Typically, it's someone that the court is able to assess, and mother did not, if that's what mother wanted at that time, mother could have made a request and presented evidence to the court to allow the court to make that type of a finding. Based on what was before the court decided the issue in front of the court, which was what mother was ultimately asking for was to continue overnight type unsupervised visitation. And that's what the court made the decision based on. Mother did not provide the court with what the court would have needed to fully consider an alternative. And
But was she at, I mean, you agree that mother said, did ask for supervised visitation during these proceedings, right?
I honestly, I'm not 100% sure that she did. I know that her attorney stated that she did, but she did not give the court what the court needed to make that type of determination. And I think that given the ongoing criminal and Children's Services investigation, that the court's determination was reasonable.
Counsel, what about this argument that in considering whether the juvenile court abused its discretion, we should take into account what might be normal or typical in other cases? I mean, as you point out, this is a private custody case, but it in many ways mimics the state taking away a parent's right to see their children. Can you address that particular aspect of your opponent's argument?
Yes, Your Honor. In terms of looking at what's typical, the law around an abuse, neglect, dependency complaint that has been filed where Children's Services is involved is different from the law in private custody cases. And the fact that the state is acting to remove children creates a very different situation that's not comparable to a dispute between two parents. And so the other part of that is that in the abuse, neglect, dependency situation, the resources of the state also come to bear, and the state is working in some way to help rehabilitate the parent. Mother in the past was in that type of a situation and did not take advantage of the resources and of the services that Children's Services offered. Mother also in Mother's brief suggested that the court could have had Mother do the services now and allowed things, but Mother has the opportunity to do that. Mother could have and could today do parenting classes, engage in mental health therapy, and refile and ask the court to look at those circumstances, the changed circumstances, and make a new assessment. But based on the information that the court had and the circumstances at the time that the court made this decision, the court's decision was reasonable. There is ample evidence to support the decision.
What's the mental health issue?
So there was a DAF completed.
Excuse me?
A diagnostic assessment of functioning completed through Children's Services back in 2018 that had recommendations for mom. Mom had also been, and I will say, the guardian ad litem raised these concerns as a layperson. I think given all the circumstances that a layperson having concerns about Mother's mental health, given her violent behavior towards father, the unexplained other criminal cases regarding violent behavior.
But you're saying there was actually a diagnostic assessment of her mental health that was done in 2018.
Correct,
So
Your Honor.
there's something there. Is that on our record?
So there was some information that the guardian ad litem, so there was that information, and Mother, even in her brief, suggests that it might have been appropriate for the court to refer her to counseling and to require her to engage in counseling.
Okay. And then what about this noise issue? I'm just stumped.
I'm not sure what exactly the noise was. From my perspective, the noise issue was not even if you take away the issue of noise, all of the other issues, particularly the severity of the unexplained injuries and the history of violence and the deterioration of the children's behavior while in Mother's care, Mother's failure to comply with court orders in the past, and failure to complete the services during the time that Children's Services was involved, that the noise issue I see as while a factor, not
least of the matter.
Yes,
Okay.
yes.
Well, you had stated that Mother could engage in services and then petition under a change of circumstances. Doesn't a change of circumstances apply to the child and the custodian?
So,
Analysis of a change of circumstances.
so in terms of, and I want to make sure I'm understanding your question. So I'm in the future, or in this case, in terms of.
In this
so
case, in the future.
For custody, there would be a change in circumstances. For visitation, so yes, in terms of custody, the change of circumstances to change custody has to be between something in the child and the custodian. For visitation, mother could come back and ask for additional visitation. She doesn't have to show, that's a best interest question, and she doesn't have to show the same change of circumstances for visitation to change companionship order as she would for a change of custody. So in this situation, the court clearly laid out in its decision that it had addressed the factors required statutorily for the custody decision and for the visitation decision. There was ample evidence at trial to allow the court to make the decision that it made. And the safety of the children is protected by the decision that the court made. It was in the best interest of the children to ensure that they were safe, and the court made a reasonable determination in order to ensure their safety. So based on the reasons that I've laid out, I asked the court to find that the assignment of error of mother are not well taken, and to uphold the decision of the court.
Thank you.
Thank you.
Mr. Kulik, you have 3 minutes for rebuttal.
Thank you, Your Honors. To clarify, the current court order for parenting time, currently mother has no parental rights for parenting time. She did have parenting time a few days ago for one of the children's birthday that was arranged between mother and father. They were able to work together for the parenting time. Father did come over to the house of the mother to have some parenting time for, I believe, 4 hours of supervised time, because father was still in the house during the parenting time. The appellee did make an argument regarding the vulnerability of the children. One child who is, I believe, turning 12 years old, who has cerebral palsy, of course, very vulnerable, nonverbal, and wouldn't be able to self-protect really in any manner. The other child is 9 years old and would be able to self-report or self-protect on some level, given the age of the child, so not complete vulnerability. If something did occur, the child would be able to report what was going on to the appropriate parent or agency. There was an allegation that mother did not complete all services. The testimony at trial from the guardian ad litem is that there was not a risk assessment ordered on mother. She did complete 2 drug screens that she passed, and she didn't have any recollection of further drug tests that were ordered that mother did not appear for. Mother also did complete parenting classes that was testified at trial, and she did engage in counseling at Talbert House. The DAF assessment that was completed, that was in 2018 and was not testified at trial by the guardian ad litem. This trial was in 2021, and if a DAF was completed in 2018, you'd have to do another risk assessment or another DAF to update it and see if anything has changed within
Was
that.
anything with regard to that assessment in the record? Is that in our record in any way, shape, or form?
I don't believe that it was submitted as an exhibit, and the guardian ad litem did not testify about it at trial.
Okay.
To my recollection, I don't believe that there's a statute that requires mother to find a willing participant to supervise. There are one of the main reasons why now Best Point, which is formerly the Family Visitation Center, was created was because it would ensure the safety of the children, because it's a facility with licensed professionals,
Well, let me
cameras.
ask you this, the parental termination statutes, there is a statute that discusses what is at the avail of the trial court in determining parental rights, and it gives different alternatives that the trial court can consider. Is there a similar statute there when it comes to custody matters? Because this was initiated by a motion to terminate mother's visitation right filed by father. And then mother files then a petition for custody, right? So that's what was being sought from the court. So the question I have is, in the motion to modify, in the private custody, is there a similar statute that lays out what are the alternatives that the trial court can consider?
I don't believe so. I believe that the motion filed by father was the motion to modify the visitation schedule and a motion for custody, and then mother had a motion for custody. And I don't believe in a private matter it specifically states alternatives for the court to
The
consider.
father didn't file a motion to terminate mother's visitation, it was a motion to modify?
Modify, and then the court decided to suspend it. Now, there was a prior court, a temporary order put in place to suspend parenting time, so the court administratively maintained that suspension of parenting time from a prior court order on an interim basis.
How would the juvenile court know that any of these alternatives were available? I mean, I assume there's some financial consequence required to engage the services of the supervised parenting.
So the contract that Hamilton County has with Best Point, which is formerly known as Family Visitation Center, allows for waivers depending on the income of the parties. And in this case, the parties would qualify for that waiver. So the services would be free absent a very small deposit. I believe it's like $25 to ensure that the children and parents show up to the visits, but they would qualify for the waiver and it'd be at no cost to the parties.
And the juvenile court would just, through judicial notice, be aware of that?
Yes, but we've been ordering it for quite some time, so all the magistrates and judges would certainly be aware of that facility and that program.
Thank you.
You are at your time.
Thank you, Your Honors.
Thank you.
Thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Thank you. That concludes court for today. Thank you all very much. Have a good rest of your morning.